If you'll give me a moment of personal privilege, I will tell you I appreciate the fact that y'all are a faith-based institution. I will tell you personally, without my faith, I don't know how I would make it through this career. I don't know how people that don't have a very well-grounded faith face the kind of troubles that we face personally and professionally. And I think my faith has allowed me to weather a lot of situations that otherwise would have done some people in, quite frankly. So I appreciate that y'all have started that foundation within this line of work. So I was looking through the classroom, and I saw a lot of things that I really connect with. I saw some stuff over there related to crime scene. I've done some crime scene type stuff, reconstruction, terrorism. I'm a firearms armor, taxes for criminal patrol, loops, whirls, and arches. Oh my gosh, I can go on for days about that kind of stuff. So I see all these things in here that take me back to not just current times, but times in the past of building some foundational concepts and proper application of criminal justice and just out here in the real world. So I looked at y'all's syllabus. I understand y'all were have focused on a number of things, mainly some criminal law type issues. I will tell you, as I call him Chief Crow, because that's how I've always known him, that there's also some aspects of like victimology and again application of crimes that are planned, crimes that are completed, issues of use of force. So pretty much anything and everything is on the table today. Does anybody have any questions for me to start off with? I know a lot of times we field questions at the end, but does anybody have any questions to start off with where I can get a start, get a foothold, or I can just go into it? Yes?
What is the biggest challenge you see facing law enforcement specifically today?
To me, I think the biggest challenge for me is making sure that people understand not just what I call book knowledge or the legalistic knowledge, but the application of those legals, which is again part of that foundational thing that y'all are facing today. Let's talk about a few things. I'm sure y'all are familiar with Miranda v. Arizona, Miranda, Terry v. Ohio, Brandon v. Connor, Tennessee v. Garner, these type of things. These are some I call it, you've heard the term tenets of a faith, okay? Different faith-based religions have what they call tenets, which are foundations of their understanding. And I think to a large degree we have the Constitution, obviously. Real big ones for us in criminal justice field is obviously the Fourth Amendment, search and seizure, Fifth Amendment, self-incrimination, Sixth Amendment, right to confront, cross-examine, fair trial, speedy trial, that sort of thing. And certainly those are the foundation and the principles that our country's been based on. But when you look at these rulings by the Supreme Court that I've talked about, a lot of people can kind of quote what those things are and what the facts of those cases are, but taking that to a level of practical application in the field requires a different level of understanding. And I think, and this is Brian's opinion here, even though I'm wearing an academy outfit, I want to be clear that some of these things are my opinion, not the position of the academy. I do see a thirst for knowledge, but I see people wanting to act too quickly and understand or kind of get to the book knowledge too quickly, and it really takes time to digest. You know, when we eat our food, it takes time for it to process. We get to enjoy the flavors of our food, but to understand the overall health and wellness to our body, it takes time. And that's the way I see our understanding of legal concepts. I'm sure y'all probably discussed or has some familiarity with like the exclusionary rule, right? Search and seizure. You know, so this is an application, and I'm going to give y'all some examples that I give students at Police Academy. And this is going to be a long answer to a short question, okay? Because like I said, you got to give me a step, and I'll go. So let's talk about Fourth Amendment search and seizure. That's where the exclusionary rule, fruit of the poison tree, comes from, right? So everything that we do in law enforcement, there is an accountability to us to explain the why we did something. We can't just say what we did. We have to explain the why of what we did. So let's take this exclusionary rule, let's take the Fourth Amendment and kind of give it a practical understanding. I tell people evidence may look good, it may sound good, it may be good, but if presented on the wrong foundation in a courtroom, it cannot be digested. So the point of that is this is a rhetorical question. This little scenario I want you to play in your mind. I want you to think of the most favorite meal you've ever had in your entire life. I mean, literally, your most favorite meal. I want you to think about it to such a degree that you can see it in your mind. You can even smell the odors that are associated with it. So for me, I will tell you that's like a big Maine lobster, big whole Maine lobster, covered in melted butter on a plate of buttery garlic mashed potatoes. All right? Now imagine that favorite meal of yours, and there's a waiter across the restaurant, and you can see that plate of food. You can almost already smell the odors that are coming over. It looks good, it smells good, right? But when they get to you, instead of giving it to you on a silver platter or fine china, they give it to you on a garbage can lid encrusted with dirt, maggots, and every other kind of filth you can think of. Say, that looked good and that smelled good from a distance, but the way that you gave it to me, I will not take it. That, to a large degree, is what happens sometimes with our evidence. If it's not presented the right way, on the legal grounds of proper seizure, as great as it may be, they can't take it. And so that is one of those kind of practical applications of Fourth Amendment type of issues. You know, we know that there's exceptions to the warrant. There's exigency issues. For example, like the imminent destruction of evidence, that might be an exigent seizure. Exigent entries, where in the right application of the law, exigent just means an emergency. Courts have recognized that there can be emergency situations where gaining someone's consent or the need for a warrant is less of an issue than acting in the immediacy to maybe protect somebody. Not that we're in there to seize evidence, but just to get into somebody's house. Let's take some issues of, let's go along those same lines of like an exigency. It's still revolving around Fourth Amendment type of issues, the need for a warrant or consent. Well, this exigency issue, again, going to proper application of the law, is, let's imagine there exists an exigent entry. You say, well, what does that mean? That means that there's a need for an emergency entry. I can't just do it because I feel like it. There's a lot of things in this job in the law enforcement field and career field you're going to have funny feelings about. But we can't operate on funny feelings. The first question we have to ask ourselves is, what gives me that funny feeling? Well, if you can answer that question, say, what gives me that funny feeling, you're starting on the basis and the foundation of being able to articulate where those feelings come from, hopefully. Now, with time and experience, that will become more clear. Early in a law enforcement career, you may say, I got a funny feeling, but I just don't know where that's coming from. But through time and experience, you start to develop a base of knowledge and go, okay, I got that funny feeling again. The reason I have a funny feeling is because these other things I went through that are similar, maybe some of those things exist here. So I'm real big on visuals. Okay, visuals really work well for me in remembering concepts. So let's imagine for a moment that we have a scenario where officers are dispatched to a house because neighbors hear a man and woman screaming. Not a fight type of scream, but a conflict type of screaming. Like somebody's getting hurt. And we understand, we do maybe do a call history in response to that call and find out there's a history of domestic violence calls to that house. We get to that house, and for what all the callers said about the screaming and hollering and the calls for help and all this stuff, we get there and it's completely silent. So silent, we can hear the grass grow. We knock on the door, expecting to get a response, something reasonable from inside the house. Someone come to the door, someone say, hey, I'll be with you in a minute, some indications of movement inside the house. But we don't get any of that. We have to start asking ourselves, can I go in there? Is there anything that allows me to go in there? I don't have a warrant, I don't have time for that. And no one's come to the door for me to ask consent and be given consent. So we have to look at this exigency issue. And again, operating on a visual, well, I don't know why it always comes back to food, but it seems to go back to food for some reason. I'm gonna look at this like a piece of cake, all right? Got a piece of cake, let's say it's just, I don't know, let's just say it's a pound cake. Just batter, that's all it was, you cook batter. Well, pound cake's pretty good the way it is. But let me ask you this, if you put more and more layers of icing on top of that pound cake, would it get more desirable? And the answer to most people would be yes. Let's imagine we put a layer of vanilla on there, then a layer of chocolate, then maybe some, I don't know, some pumpkin spice, keeping with the fall. You know, oh man, that's great. That's getting better by the minute. But here's the thing. Is that piece of cake by itself, in other words, the facts and circumstances as I know, is that piece of cake going to be sufficient for the court to say that I was within my rights of an exception to a warrant and consent to go in there? Well, I don't know. It's case specific. Maybe that one thing, maybe that piece of cake, maybe that one thing I can articulate is enough to satisfy the standards as applied by the judge. But my question is, if we add multiple layers, do our chances go up that we'll find success? And the answer is, it is. I mean, one thing may be enough, two things may be enough, but if you've got 7 things, how much better is that? So let's imagine for a minute, we got let's take the scenario. We got anonymous calls that at 100 Main Street, there was a man and woman screaming. Specifically, they heard someone say, "Don't kill me." Now, the courts say, well, anonymous information, courts don't give a whole lot of weight to anonymous information. But we do. And what I mean by that is, I get that call for service, I still have to go. But I can't just take that anonymous information, I have to validate it, I have to verify it. I may not even know that 100 Main Street exists. But when I find it, am I starting to confirm location? Yep, 100 Main Street exists. I did a call history, there's a history of domestic violence there, so now I got 6 things. I knock on the door. Well, first of all, it's silent. Well, I'll tell you right now, sometimes time and experience can be a good thing to articulate. I will tell you that as a law enforcement officer, if I hear a lot of screaming and yelling, or there's indication of screaming and yelling, I hope they're screaming and yelling when I get there. Because when it's silent, that means something bad could really happen. So I think the silence is a contradiction or an antithesis to the screaming and yelling that's heard by the anonymous caller. And then I knock on the door expecting some type of reasonable response, and I get none. What might have been 1 or 2 things is now not. So, having to articulate to the court why a reasonable person would believe that someone inside is in need of immediate aid, I think I am in a much better position to argue my point and be found to be correct, to be right, than if I just had to. Now, specifically to South Carolina, we have this 2004 South Carolina Court of Appeals case called State v. Abdullah. And it says, when officers have reason to believe that a person inside is in need of immediate aid, they can make warrantless entries and searches. That 2004 South Carolina Court of Appeals case backs up South Carolina Supreme Court rulings on exigent entry and U.S. Supreme Court cases on exigent entry. So we daisy chain all these things together. Again, taking this book knowledge to practical application, that's where we operate with confidence and authority to properly apply criminal justice and law concepts. Real quickly, as a reminder, remember with Miranda, Arizona, that's giving that Miranda warning, which ties into Fifth Amendment issue, self-incrimination. You got when someone's detained, they're not free to leave, they're being questioned, and they're the suspect of a crime, and those questions could incriminate them. The Miranda protections need to kick in. Courts have given us direction through Miranda v. Arizona. Tennessee v. Garner, fleeing felon rule. They've given us guidance. People can tell you the case all day, but do they know how to apply it to the real world in a matter of seconds? Can they examine if there exists a further danger or a continuing danger to the public or other people by letting this felon go away, and can I properly use lethal force? Graham v. Connor, okay? Talking about use of force, not just deadly force, but just excessive force. How much force is necessary to accomplish a lawful action by an officer. You know, so these concepts, again, are, aside from the Constitution, are the tenets by which we operate when we are judged in whether we do our jobs correctly. So a long answer to a short question. Any other questions? Well, let me give you some words of wisdom, okay? Now, first of all, I know there's some people that aren't in the class today, and I don't know how each of you, I don't know what your approach to this class is. I don't know what your ultimate goal is. But this obviously is a foundation for something. Be confident in your abilities. Be confident in doing what you know that you're doing and you're doing well. There may be some apprehension. There may be some stress related to just your time in college. I was subject to that. See, y'all, everybody experiences stress for different reasons. Okay? Your stress and your stress and your stress and your stress, you know, it's all different. Now, maybe the same in some aspects, but you're all individual peoples, and what may stress one of you out doesn't stress another. And so, within the collegiate world of study and practice, there may be a level of stress on getting and applying what you're learning. I will tell you this, I used to have terrible test anxiety. And I'm going to take this to a work application. I used to have terrible test anxiety. I was always a pretty good test taker. I'm not the best standardized test taker, because I think, to me, this personally, I kind of think outside the box. The standardized tests don't fit the mold that I like. I like to think outside that kind of standardized way of thinking. But, and when I got into college, obviously it became much more critical as far as like test preparation and passing tests and exams. I'm going to tell you right now, your whole life you're going to be tested. Your entire life. It's not always on a test and always from a book. Life's going to test you. However, my approach that changed my entire way of thinking is just the idea of placing my anxiety where it needs to be or eliminating it completely. So how do you do that? Well, go back to our biblical, place our anxieties upon the Lord. He's asking us to put our anxieties at His feet and let Him handle it. So when we operate in faith and we operate in what we know that we are doing, there comes an area of peace. And what I mean by that is during the study process, I questioned myself. Brian, are you studying as good and as effectively as you can? And the answer to myself was yes. Everything that I knew to do or was taught to do for correct study preparation, I was doing and doing to the best of my ability. And that is where things needed to rest. If I did things to the best of my ability and I did well, fine. If I came up short, then it is what it is. And that is where some of the anxiety left me, with the confidence. Yes, sir?
Yeah, kind of on that, something the Lord revealed to me a couple years ago is that no matter where we are, we never have full control of the circumstances of the situation. But what we do have control over is our response to it.
Absolutely.
In every situation.
Absolutely. You know, you couldn't be any more right. And so where some people may have some anxieties, trust yourself and ask yourself those questions. Am I doing my best job? Not just for myself, but I'm doing my job to a degree that the man upstairs, that God would say, you're doing everything. You're doing what you're supposed to do. When you do all those things, whatever the outcome is, you have to trust there's something else going on. Okay? I will tell you, going into a different area of work, or not my work, but friends' work, I got some friends of mine who are military pilots. Not everybody going through flight school has the easiest time. Some people are innate, it's born into them to be pilots. Other people are trial by fire, and they work and they work and they work and they hustled and they struggled, but they got through it, and some washed out. The ones that washed out, it doesn't mean that they didn't have the desire, but it meant there was something else for them. Within my own experience, not everything that I set my foot towards was met with success. But there is a peace in knowing that whatever the outcome is, if I've done my best ability, there is something else for me. And so we don't need to worry so much. I can do all things through Christ who strengthens me. That is true. But also understand God has a will for you, And sometimes our desires are not His ultimate plan for us. I'll give you a perfect example. Couple of examples. I always wanted to be a pilot in the Air Force. When I graduated high school in 1991, my plan was to go into college, get my commission, and fly jets. At that time, President Clinton was doing base closures. All the service academies and all the ROTC programs in college said, yeah, we can get you a commission, but as far as flying, good luck, because we got too many pilots. Now, they're begging for pilots. They don't have enough, which I find kind of ironic, because everything's going to remote pilot everything, and so they're like, we don't have enough pilots. I'm like, really? I was born in the wrong decade, I guess. But so that didn't work out, but I was like, I was very disappointed, because to know about me, my first word out of my mouth wasn't mom or dad, it was airplane. That was my first word. My entire teenage years was built around nothing but flying. So I got really disappointed. I got really disappointed on that. And I didn't know kind of where the path was going to go. And then when I got into college, I knew I had to do something that was going to have me locked up in a classroom or an office all day. So law enforcement kind of was that next fit, having that diversity of being out there doing things, what I call boots on the ground, doing the active work, and then doing some administrative type stuff. And when I was in college, I decided I wanted to be a Fed. And specifically, I did an internship with the U.S. Marshals Fugitive Task Force Unit when I was in college. Even though my internship was done in about 40 hours total, the U.S. Marshal at the time, Israel Brooks, he actually let me stay for a year. Because I asked him, I said, hey, I want this opportunity, I want this exposure. And for a college intern to go into the Fugitive Task Force Unit was like unheard of. You had to go through like a national security background check, FBI check. I mean, it was all kind of just like you were already a qualified federal agent, because everything in there was like government computers and secret databases and all this kind of other stuff. So I wanted that experience. So I set my sights on I want to be a deputy marshal. And came out of there, went to go work for a large city police department, then worked for a small city police department to get some more experience. And trying to make myself as well-rounded and as marketable as possible. The two agencies that I was at, they sent me to 35 to 40 different schools. Gang and drug investigations, crime scene, criminal investigations, gang and drug, interview and interrogation schools, blood pattern analysis. I mean, you name it, I went to it. And ultimately, I got hired. I got hired by the Marshals in 2004. And I didn't make it through. I did, but I didn't. I got hired. I went through. There was 75,000 applicants for 250 deputy marshal positions. It took me 4 years to get hired, to go through that whole process. I get there, and it was not what I wanted. It was not what I thought. I've been asking God for years. I said, God, give me this opportunity, give me this opportunity. And I will tell you, He gave me the opportunity that I wanted to realize that's not what I needed. I'm telling you now, a bunch of stuff fell into place that I had no control over for me to get that selection. Things that had nothing to do with me. Things that I know had everything to do with Him, because there were entities and people all along the process that had no attachment to each other or anything, and all these chess pieces had to work together to get me what I wanted, just to get there and go, you know what, this is not what I wanted. And I was disappointed. I was disappointed in myself. I was disappointed that I let my parents down. I was disappointed that I let God down, because I was like, God, I asked for this, and I feel like I dropped the ball. But what I came to realize is there were bigger things in store. So as you progress through your collegiate studies and into your careers, again, remember these stresses and challenges are going to come. But as long as you're doing your best, as long as you're doing a good, diligent work that you know that yourself, the Lord, will be proud of, it is going to work out the way it's supposed to. You don't need to fret about it. So that's a little word of advice, if I could share any with you, because I don't know what your ultimate goals are. But I will tell you, I think the Lord is diligent in understanding our desires. I think to a lot of degree He puts the desires in us, but also they have to be in accordance with what His overall goal is for us. And some of those trials and things we go through is His ability to get us to certain places and appreciate where we end up. So, I will digress for a minute. Let's get back into some other kind of concepts that we see in law enforcement training. Chief has heard me say this before. We get paid to be lawfully nosy in law enforcement. As law enforcement officers, we are in a unique position to put our nose in the things that many people would want to avoid, but by the nature of our job, we have to be involved. You know, interpersonal issues, interpersonal violence, domestic violence, I don't care. So some of my areas of specialty is like vulnerable adult and elder abuse, domestic violence. I've got some background in sexual assault investigations and child abuse and that sort of thing. Those are some pretty horrible things. And one thing you got to understand about the public at large is the public, even if you are doing nothing wrong, the public doesn't like the government in their personal business. So when people call law enforcement and are asking for law enforcement to be involved in their personal business, you realize that they've probably reached their limit as to what they can handle themselves. Because again, that's not what people want. They don't want strangers come into it. Or as the situation itself calls for us to be in someone's world even without invitation. This is where good-hearted and good-minded people call on behalf of other people for us to intervene in situations. And so in our duties, we have a responsibility, and again, I think it's a duty, that we have to inquire very deeply into what's going on with people, even though they don't want us to. So to that end, in the law enforcement field, if you get into it, especially in the law enforcement side or prosecutor side, you cannot operate in ambiguous or gray information anymore. Because you just can't. Because ambiguous and gray information does not give you clarity to make decisions. So there's this little matrix, and honestly, I don't know where it came from. I just remember one day I was sitting in my office and this idea popped into my head, and it probably is based on multiple concepts over the years that I've kind of combined together. But everything we do starts with observation. Everything that we do in the criminal justice field starts with observation. Now, with regard to that, if you've never been taught what to look for, you're not going to see it. It's a skill. It's a skill. Skills have to be developed. The skills of observation are something that has to be learned. The skills of interviewing people is something that has to be learned as well. So everything starts with observation. If there is, in the criminal justice field, or the law enforcement field, or the field of prosecutors, or even defense attorneys, if we see something, or we hear something, or our senses pick up on something, I'm going to call that observation. I know that may not be the technical term. They may say, oh, well, observation by definition is something visual. Well, I think observation relies on all of our senses. We call it situational awareness in law enforcement. Our senses tell us what's going on, or they give us indications. So everything starts with observation. When we observe and we then develop a question or a suspicion based on that observation, there's only one thing we can do with that. The only way to settle suspicions and questions in your mind is to ask, suspicions is to ask questions. This is where they get being lawfully nosy, to understand. I have to ask questions. So take any situation that you're in. I don't care if you're at the mall, I don't care if you're at the movies, but watch people, watch things, and when something's telling you, I don't understand what I'm seeing, I don't understand what I'm hearing, I don't understand why I'm feeling this way, then that's your body going, I need an answer. The only way to settle that is to ask questions. Some of these things I'm getting ready to say you may have heard before. You miss 100% of the shots you don't take. If you don't drop a bucket into the well, you'll draw out no water. What that means is if you don't ask questions, don't expect an answer. You may not get the complete answer, but you will get some answer, and it's more than what you have. The more clarity you have, the more answers to your questions, the better facts you operate in. Then comes the last part. So we have observations lead to suspicions, suspicion lead to questions, questions lead to answers. And when we have answers, we make better decisions. So it doesn't matter, again, what you're dealing with, but in the criminal justice realm, that is kind of the way we operate. It's a daisy chain of concepts that one flows into the other. And so people say, well, how do I know what questions to ask? That's another whole aspect. Okay, I observe, I come up with a question or a suspicion in my mind, but how do I ask it? Well, you know, again, you can't operate in ambiguous information. You can't operate ambiguous or assumptive information anymore in the criminal justice field. You've got to get clarity. So there's what I call questions and good questions. Let's just take domestic violence, for example. You know, my kind of wheelhouse. I don't like that word wheelhouse. I think it's overused, but it's the vernacular, and it's the kind of what we use these days, and people understand what we're talking about. So, let's say we've got two people. Now, in South Carolina, our criminal domestic violence laws relate to a definition of household member. So, domestic violence laws apply to people that are spouses, former spouses, persons that have a child in common, people that are cohabiting, that means living together in a romantic or intimate situation, or have formerly cohabited, so it means formerly lived together. And a 2015 United States Supreme Court ruling applied those to same-sex couples as well. That's what we have to consider. That's the law that's before us. So you pick whatever dynamic you want in your head, men and women, male, male, female, female, facing a situation where there's been some type of conflict between the two of them. DV law says that you cannot threaten, you cannot offer, or attempt to cause physical injury on your household member. That means there cannot be words of threat and there cannot be actions which could have been completed towards a household member. And that could be criminal. There's also an aspect of that statute that says parent-present ability. And you'll see why this all ties together. And fear of imminent peril. So you cannot cause physical injury on your household member. You cannot offer or attempt to cause physical harm or injury on your household member with the apparent present ability creating fear of imminent peril. So, that's a lot. Well, that's law enforcement. That's prosecution. Elements of crimes. Take any crime, same thing. Take conspiracy, you take robbery, burglary, same thing, elements of crimes. All right? So let's take this whole idea of observation, questioning, understanding to a domestic situation. So you got these two parties, and I observe that. I'll pick a case that was actually one of mine. Male and female, guy's got a broken finger. Now, I can't go in there and go, hey, he's got a broken finger, he's the victim. I don't know. Just because someone has an injury doesn't mean they're a victim. People have the lawful right to use self-defense. And a lot of that comes back to their perceptions as to what was going to happen or what did happen. Well, that's the way I have to operate. I can't just come in and go, hey, they're a victim. I got to be fair to both sides. So I'm making this observation. I'm sitting there now observing. I wonder how his finger got broken. So there's the question. Using my observational skills, I'm looking around. There's a bloody skillet laying on the floor in the kitchen. Now I'm starting to think. I wonder if that bloody skillet has something to do with the broken finger. Another question, right? There are two parties in the house. Is there anyone else in the house? Another question. Is it just these two people, or was it more than these two people? Was someone else involved? So we're starting to get those observations leading to questions. So now I've got these two people. I've got them separated, sight and sound separated, because I need to interview them both. And I could ask something like, so I'm going to tell you, there's a female in the house, okay? I'm going to need some audience participation here, okay? Got a female in the house. Male in the house got a broken finger. We go to the female. Can you think of any of the questions that the officer might ask her? Okay, son.
What was the reason for the call?
Say what?
What was the reason for the call?
What was the reason for the call? Okay, that's a good one. Now, in this case, I will tell you, I'll get full disclosure, I didn't give it. It was called in by a neighbor who heard a man screaming. So it wasn't even people in the house that called. Ma'am, did he hurt you? He put his hands on you?
Yes.
Okay, let's take that. Listen how I asked the question. What was the form and content of my question? Did it suggest an answer? It did. That's what we call a leading question. That's not good. Because if I'm asking that kind of leading question, where does it tell you about where my mind is on who victim, who suspect is? Man, did he hurt you? Where does it tell people that my attention is focused as the aggressive party?
The guy.
The guy, right? That may not be the truth of the situation. Okay? And then you answered in what we call the affirmative. Yes. All right, now I question to that. If she says yes, has she explained the how and the why the finger got broken? If she is saying yes to, did he try to hurt her, do you have any understanding as to the why and how he tried to hurt her? No. We don't have clarity because we asked a bad question. Okay. Take the guy, same thing. Sir, your finger's broken. She break your finger? Yep. Or what if he says no? Sure didn't. Now come on, sir. It's just you over here, man. Put a skill in it for you. You got a broken finger. Did she break your finger? No, it didn't. Nothing happened. No, it didn't happen that way. Still suggested an answer. Now we get a no. Well, what's the good follow-up question to a no? He's already said no twice.
What did that?
I'm going to ask you 10 more times until I get what I want to hear. It doesn't work that way. That's a bad question. So to be fair to both sides, we take what question we want to ask, and instead of it being leading and closed-ended, we have to have it open for detail, right? Ma'am, I noticed that there was a bloody skillet on the floor over here in the kitchen. Tell me how it got there.
He was attacking me and I grabbed it to defend myself.
Oh, okay. Sir, there's a bloody skillet on the floor in there. Can you tell me how it got there? The reason we cite and separate people in domestic situations is we don't want them to feed off of each other. In other words, we don't want one to cover up for the other. And that commonly happens with a lot of your victims. They will cover up and they will fill in parts of the story to back up what an offender may say so that you have a hard time figuring out who the aggressor is. Okay? But what I'm going to do is I take the questions that I want to ask and I put the word explain in front of it. Because explanation requires detail. Because if I ask you, explain to me how the skillet got on the floor, and you go, yes. Well, does that answer fit for the form of the question? No. Either they're being evasive or they don't want to tell me, you know what I'm saying? So that tells me something's not there. Go back to a time when you were a lot younger and probably did something wrong and your parents came to you. Who broke the lamp? Not me. Knowing full well you did. Our parents knew something was up. Because there wasn't but a few things to put it on, you know. So what we do is we ask clarifying questions to get understanding. Now, what I would ask her in response to that is, where were you, where was he when this started? Explain to me what was said during the argument. Explain to me what was done during the argument. I would tell him the same thing, being fair to him as well. So in this particular case that I was working, his story was, when I asked him to explain, he said, look, I just got up, I went into the kitchen, my wife was over there by the stove. Okay, so where were you? I was right here. So you're like, 10 feet away? Yeah. Okay. I just come out of the bedroom, and I asked her what she was cooking. And I don't remember specifically what it was. Let's say, she was cooking spaghetti. I said I wanted lasagna. She started cursing at me and yelling at me and telling me that I could make my own food, and if I didn't like what she had to cook, I'd come do it myself. And I told her to calm down, and when I told her to calm down, she started yelling and cursing at me again, and I started cursing back. She needed to be quiet. Okay, sir, well, all right, so I understand y'all are arguing over food, y'all are cursing. Anything else that I would need to know about? Why? Because you can yell and you can curse at your significant other. That's not a violation of law. Remember what's a violation of law? The offer. I'm looking at what was said during the argument. Not what the argument was about, but what was said. So what I'm looking for both parties to say or to hear, indicate, is some threat. Well, in this case, there was no threat. There was no conveyed threat. So the next thing is, okay, what if anything was done? So, sir, when y'all were cussing and yelling at each other, what if anything did you do? Well, I stood right here. I just kept throwing my hands up in the air like this is ridiculous that we're having this type of argument. Okay, what did she do? She picked up a skillet off that stove and threw it right at my face. Oh, okay. So, she threw it right at your face from over there. 10 feet away? Yeah, okay, cool. All right. So, sir, what if anything did you do? Explain to me what you did. I didn't have time to do anything. That thing was coming to me so fast, all I had time to do was put my hands up from my face. And then, well, what happened then, sir? And then I had my hands down, and then I felt that pan hit my finger. I felt the pop, I heard a pop, and I started screaming. What the anonymous caller said at the beginning, I heard a man screaming, all right? All right. All right, sir, then what did you do after that? I was cursing and yelling. I went up to the bedroom and get a T-shirt to wrap my hand in because I had blood streaming down my hand. All right, so that's his version of the events. To her, same type of form of question. Man, what if anything was said? Oh, we were cursing and yelling and all this other kind of stuff. You know, we were arguing. Where were you? I was over here by the stove, and he was over there. Okay, cool. All right, and what if anything did he say? Oh, he called me, I was a good for nothing blankety blank, and I told him he needed to shut his mouth. And what I'm looking for is any indications that the act was out of defense or protection. But there was no indications of that, and I can't feed them that story, even though I might think that might be part of it. I can't give them an idea and ask them a leading question. So she's like, oh yeah, he was arguing, you know, he'd come over and fix this food himself if he wanted to. Okay, and then what happened next? Well, I had the skillet in my hand and I just threw it in his direction. All right, so threw it in his direction. Do we now have confirmation the pan was thrown? Do we now have confirmation who it was thrown by? Do we have confirmation in what direction it was thrown? And what we don't have is, was she throwing it at him or in his direction? I'll be honest with you, it really doesn't matter. Because what I have now, what I've kind of been fair to both parties, what I've heard is there's been no indications. Every opportunity has been given for the details of why this female, in this case, might have been threatened and needed to act in defense or protection. But as it was, she acted out of anger, and she threw this pot, this skillet in his direction. But for the fact, had the skillet not been thrown, would he have had a broken finger? So this is where it comes into asking the next questions, good questions. So now we look at this domestic matrix. Was there an offer? Nope, there was no threat. Was there an attempt? Yep, somebody threw a skillet. Was that directed to a household member? Yep, they were married. All right. What about the present ability? Well, I don't know. Now that we know that they were in the kitchen, and she was 10 feet away in front of the stove, and he was, you know, on the opposite side of 10 feet in front of the bedroom, is there the ability to be harmed from 10 feet away when somebody throws a skillet at you? Got that. And then we get fear of imminent peril. Well, you know, we're standing there, guy, he's not acting fearful. Police are there, he's like, I got this broken finger, I'm upset. Okay, but what did he do when the skillet came at him? Why do you put your hands up in front of your face? Because you're worried, right? There's some fear that I'm going to come to harm. So, in asking him, sir, I know it sounds silly, sir, but why'd you put your hands up in front of your face? Because I thought that skill was going to hit me right in the face and probably break my nose or something. Now we've got actions and words that back up the imminent peril. And in the DV law, we don't have to have show intent. But for the fact, had she not thrown that skillet? So now we're looking at an issue of what? Starts with PC. We're possibly looking at an arrest. What do we have to make an arrest?
Probable cause.
Probable cause. Let's see if we operate in the ambiguous or the gray area. We can't get to that point. Now I can say with taking pictures of the crime scene, evidence type stuff, taking pictures of the crime scene, taking pictures of him, taking pictures of his broken finger, having the paramedics and EMTs come in to verify with a medical professional. See, the paramedics and EMTs coming in, they're not coming there to make a criminal case. I'm coming in there to help them triage and stabilize somebody. They come in and they can look at a finger and they can put in their notes, Mr. So-and-so's finger was broken. We advised him to go to the hospital. So now I take all these statements, testimonial evidence. I take documentary evidence, which is not just my incident report, but the documents from the paramedics and EMTs, their testimonial evidence as well. I take my physical evidence, that bloody rag he had in his hand, that bloody skillet laying on the floor. The pictures are also documentary evidence, along with the tangible stuff is the physical evidence. The documentary evidence is the pictures. We take all that stuff, we present it to a judge for a warrant, or we take it to trial, and there comes the examination of our probable cause and what level do we need to find someone guilty in court. What's the standard we must meet? Sorry?
Beyond a reasonable doubt.
Proof beyond a reasonable doubt. I don't have to have proof beyond a reasonable doubt to make the arrest. I got to have probable cause to make the arrest. But if I package my case correctly, what I'm hoping to reach is proof beyond a reasonable doubt for the person that's been charged for the crime.
The bell is about to ring.
Okay.
I'm so sorry.
No, that's fine.
You
Question.
can start your question.
Yeah, my question was, you would only pursue arrest if the individual that was harmed wants to proceed in that manner, correct?
No.
No?
Yeah, so a quick application of law. So, in assault crimes, okay, there can be some discretion on whether law enforcement or whether the victim is going to press charges on an assault crime. So, like a misdemeanor assault, law enforcement officers, we can make an arrest for crimes that were freshly occurred, even though they did not occur in our presence. They're freshly occurred. Assault law. If it's a misdemeanor and the victim does not want to pursue criminal charges, the law enforcement agency has a right to comply with that request. A felony level charge, that's probably going to be taken out of the hands of the law enforcement officer, but with respect to domestic violence in South Carolina, the state bears the burden on deciding the prosecution of a domestic violence case. It's not the victim. The victim can express it, but our Title 20 law, there's Title 16, which is our criminal law for domestic violence. Title 20 law is for our orders of protection and things like that. It says that the primary job of a law enforcement officer in domestic violence is to enforce the law and protect the victim. So the burden to decide prosecution rests on the law enforcement officer in a domestic incident, because most victims will never testify or prosecute their offenders, which leaves a cycle of violence to continue and get worse. So that's the big difference.
He's got cards and some other information. Any questions you want to ask him? I mean,
I'm gonna stick
he's
around,
around for a little bit, so
yeah.
we can go out in the hall, but I'm sure you can email him or ask me to pass questions on. But you've gotten tons of good information today. This is very helpful. I learned a bunch today. So let's thank him and express our appreciation.
Thank y'all. Yeah, good luck to you. You're gonna do amazing.